Hello, everyone, and welcome to One Civil Law. And for today's story, we have a follow-up on the continuing issues of Karen Read, namely with respect to her habeas petition. You'll recall that Karen Read was once on trial for the murder of John O'Keefe, and the jury came back with no verdict. Or did they? As some of the members of the jury have said that they, at least in their own minds, thought not guilty. So, we are facing a second trial, and Karen Read has argued double jeopardy, namely that the jury did or should or effectively did acquit her, and therefore she cannot be retried. She appealed to the Massachusetts Supreme Court, which denied her appeal, and she has sought a collateral attack in federal court on federal law. This is a habeas posture. It is not an appeal, it is a collateral attack, and therefore somewhat disfavored as a matter of law, generally speaking. And of course, the law that she was going for seemed to be a bit problematic, as we've discussed. So there were definitely some chances, but I didn't think it was overall probably likely on balance, and the district court has said no. But the reasoning for why they said no, of course, is the thing. So we're going to discuss the federal law as it relates to this. So let's go ahead and get started with this. We are in the United States District Court, District of Massachusetts, in Karen Read versus Norfolk County Superior Court and the Massachusetts Attorney General, with a memorandum and order and petition for the writ of habeas corpus. Thus, writes the judge. This is a petition for writ of habeas corpus under 28 U.S.C. 2241. Petitioner Karen Read is under indictment in the Massachusetts Superior Court for second-degree murder and two other charges. She was tried on those charges beginning on April the 16th of 2024. On July the 1st of 2024, after the jury reported it was deadlocked, the trial judge declared a mistrial. Petitioner then moved in Superior Court to dismiss two of the three counts on the grounds that double jeopardy barred retrial of those charges. The Superior Court denied the motion, and petitioner appealed that ruling to the Supreme Court of Massachusetts. The Supreme Court of Massachusetts affirmed the district judge by unanimous vote. Petitioner then filed this collateral habeas petition. The retrial is currently scheduled to commence in Superior Court on April 1st of 2025, a date that is looking more and more plausible. The issues presented by this petition are limited to those arising under federal constitution, specifically whether retrial would constitute double jeopardy in violation of petitioner's right under the 5th and 14th Amendments. So, of course, only the federal court can rule, well, not only the federal court, but ultimately the federal court can rule on federal law, and of course the federal court can only decide federal questions, typically speaking, and this is no exception to this. This is a federal issue. So that's what we're here for. For the reasons set forth below, the petition is denied. Then let's go through the background. On July 9th, the Commonwealth of Massachusetts charged petitioner Read with second-degree murder in violation of law, manslaughter while operating under the influence in violation of law, and leaving the scene of a collision resulting in death in violation of law. A jury trial began in Norfolk County Superior Court on April 16th in 2024 and lasted more than 2 months. I know, you know, we watched it together. It was definitely a thing. At the close of the evidence, the jury received instructions concerning 3 charged offenses, as well as 2 lesser included offenses in count 2, involuntary manslaughter and motor vehicle homicide. As part of the instructions, the trial judge indicated that the jury would receive separate verdict slips for each of the 3 charges, which of course they did. The foreperson was directed to check the appropriate boxes as to each charge and notify the court once the jury had reached a unanimous verdict. The trial judge further instructed the juror to continue deliberating until they have reached a final verdict on each charge and not to disclose their progress or standing as to any charge until they reached a unanimous verdict. On the jury's 3rd day of deliberation, the foreperson delivered a note to the jury. At that point, the jury had been deliberating 19 hours. In the entirety, the note stated the following. That's definitely not the only thing the note said. That's not the only thing the note said. The note went on longer than that. So he says in the entirety, but this is not the entirety of the note. But whatever. He says, I'm writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we've been unable to reach unanimous verdict. The court then read the note into the record. And the invited argument from the parties as to which note, whether it should issue a Torrey Rodriguez charge. Oh, this is the first note. Oh, okay. It's the first note. I misunderstood. I made a mistake. All right. That was the first note. That's fine. That was the full note. Okay. My mistake. The All right. The court read the note into the record and then invited argument from the parties as to whether it should issue the Tui Rodriguez charge, which is the Massachusetts equivalent of the federal Allen charge. Such an instruction, otherwise known as a dynamite charge, is designed to urge the jury to reach a verdict by giving more serious consideration to opposing points of view when the jury is deadlocked after due and thorough deliberation. The Commonwealth opposed the instruction. Counsel for the petitioner, however, asserted the jury's use of the term impasse and exhaustive indicated the jury's deliberation had been sufficiently due and thorough and warranted the instruction. Given the length of the trial, the volume of evidence presented, and the complexity of the issue, the trial judge determined that due and thorough deliberation had not yet been completed, and thus the dynamite charge was improper at that time. At around 2:45 in the morning on the following Monday, July 1st, the foreperson submitted a second note. By that point, the jury had deliberated for approximately 24 hours. The second note stated, "Despite our commitment to the duty entrusted to us, we feel ourselves deeply divided by fundamental differences in our opinion and state of mind. The divergence in our views is not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consent is unattainable. We recognize the weight of this admission and the implication it holds." After soliciting further argument from the parties, the trial judge determined the Tui Rodriguez/Allen charge was appropriate at that point. The court noted it had never seen a note like this from a jury reporting an impasse. It was particularly well written. The instructions were given to jurors who returned to the jury room for further deliberation. Later that day, around 2:30 in the afternoon, the foreperson delivered a third note to the jury. By that point, the jury had deliberated for nearly 30 hours. The third note stated, "Despite our rigorous efforts, we find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charge. This deep division is not due to lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serves to force us to compromise these deeply held beliefs." The court read the note into the record before the parties, which she did, directed the jury be brought into the courtroom and declared a mistrial. Not necessarily in that order. The court then just charged the jury and discussed setting for future conferences with the parties. Petitioner counsel did not object to the court's objection at any time, discussion, or asked to be heard on that topic, which I think is still the biggest issue, even though, ironically, or not perhaps, the issue of consent was never raised at the oral argument, which I found to be a bit odd. But I still think that consent is the most likely issue for the trial judge to make the decision. I think that if we're going to go with the issue of manifest necessity, unless the federal judge is stuck with the finding of the state court that they had given sufficient consideration of the alternatives, so unless they're stuck with that, I think manifest necessity probably leans in favor of Karen Read. If they are stuck with it, probably not. And as to whether they were stuck with it or not was a bit of a quandary of a legal question that was very interesting. So that was one thing. But I thought that the easier way to resolve that issue, or resolve the issue, was to resolve the issue of consent. And like all good courts, you want to look for the easiest way to resolve the issue. So it's like, if I can resolve this issue on consent and I don't have to deal with that messy issue, then that would be nice. But consent never came up with oral argument, which I found to be a little bit weird, but whatever. All right, post-trial events. On July the 2nd of 2024, one day after the trial concluded, Juror A contacted one of the petitioner's counsel to inform him the jury had agreed defendant was not guilty of either count 1 or 3. The following day, July 3rd, a person who was not a member of the jury sent petitioner's counsel screenshots of a text message from Juror B saying, among other things, it was not guilty on the second degree, and split in half for the second charge. Another person not a member of the jury sent petitioner's counsel screenshots of text messages summarizing conversation Juror C had with friends about deliberation. According to this intermediary, otherwise known as hearsay, manslaughter started polling at around 6-6 and then ended in a deadlock 4 no, 8 yes, because Karen Read was there, John O'Keefe was there, therefore Karen Read did it, don't you know? Several days later, Jury D contacted petitioner's counsel to explain the jury deadlock related only to count 2 as lesser offenses. Juror E similarly contacted petitioner's counsel to explain the jury had been deadlocked only on the lower counts of count 2. Based on the subset of these statements, petitioners filed a motion to dismiss count 1s and 3 1 week after the declaration of the mistrial. In substance, petitioners argue the jury's post-trial statements demonstrated the jury had effectively acquitted her as to those counts, rendering a potential retrial unconstitutional. She further contended declaration of the mistrial was improper as to those two counts, and the court, as minimum, should conduct a post-verdict inquiry to verify the counts, which there's no way we're going to do that unless it legally matters, right? Unless it legally matters. That's the thing. Does it matter? Does it matter? We have to resolve that issue first. Only if we decide it matters, then we'll bring in the jury to find out what the answer is. But the answer doesn't change anything. Why even bother asking the question, right? So at the moment, we're trying to figure out, do these random musings from these, even if it's all 12, do these have some sort of legal import? Do they have a legal import? And I was like, I don't think so. I don't think they do. I don't think they have a legal import. And we're going to find out why the trial judge said no, what their grounds of saying no is, of course, as important as anything else. After petitioner's counsel of jury attested to jury communications part of petitioner's motion to dismiss, the Commonwealth also received communications from several jurors. One juror left the prosecutor 2 voicemails saying the juror had voted not guilty on counts 1 and 3 and had voted 9-3 on the lower manslaughter charge. 3 other jurors emailed the prosecutor asking to speak about deliberations anonymously, but declined to do so after they were informed the Commonwealth might have to disclose what they said to petitioner's counsel or the court, which, fair enough. I can't necessarily guarantee your anonymity. I might have to reveal that to the court. A perfectly reasonable thing to say. After hearing argument, the trial judge denied the motion to dismiss on counts 1 and 3. The court said there had been no open and public verdict, affirmed in open court, acquitting petitioner of any charges. The court also rejected petitioner's contention the declaration of mistrial was inappropriate, knowing petitioner herself had twice requested the deadlock instruction, which, as the court noted and I noted many times, is typically the last step before a mistrial, which is kind of a big thing. It's like it's a little bit hard for the defense to say, we were totally caught off foot. We had no idea the judge was going to say mistrial. It's like, I don't buy that. I do not buy that at all. It's like you gave the instruction. If you didn't know mistrial was lurking in the air at that point, it's like, I don't know what to tell you, man. You're just not paying attention, man. You were just not paying attention. In light of jury's multiple notes indicating a deadlock, the court concluded mistrial was necessary and appropriate. Let's talk about the appeal to the Supreme Court of Massachusetts. On September the 11th, 2024, petitioner filed a petition, seems repetitive, to the Supreme Judicial Court of Massachusetts. On February the 11th, 2025, the Supreme Judicial Court affirmed the trial court's denial of the motion to dismiss. The Supreme Judicial Court held the trial court properly acted within discretion to determine the jury was at an impasse and the trial was at a manifest necessity. It based that conclusion primarily on the jury's increasingly emphatic notes, some of which echoed language from other cases where the Supreme Judicial Court has characterized a jury's report of deadlock as unambiguous. It went on to reject petitioner's contention that no manifest necessity had been established because the trial judge adequately failed to consider the mistrials, and whether or not this is a conclusion of law or a conclusion of fact is an interesting issue that we'll see whether or not the court here resolves that issue. Accordingly to the Supreme Judicial Court, the judge did consider and pursue such alternatives by taking a measured and iterative approach, breaking the deadlock. The Supreme Judicial Court specifically rejected petitioner's other proposed alternatives, including inquiring about a partial verdict or polling the jury. It found while the relevant law allows a trial judge to inquire about a partial verdict, a judge is not required to accept a partial verdict before accepting a mistrial, and is prohibited from doing so on a single indictment that contains lesser included offenses. The court gave great weight to the fact the record before the trial judge suggested complete deadlock, where the first and second notes provide no indication of partial consensus, and the third note plainly implied the opposite. It also emphasized these notes indicated additional inquiry in the jury deliberations risked posting a coerced verdict. The Supreme Judicial Court also rejected petitioner's claim the trial judge abused discretion by declaring a mistrial without notifying the defense of the third note's content and without allowing them to express their views. It found there was no indication that inviting defense counsel to participate in a third round of consultation would have proved any fruitful alternatives, which, not necessarily an invalid perspective, under the relevant law. The Supreme Judicial Court then held because the jury did not affirm the petitioner was not guilty of count 1 and 3, there was no acquittal barring retrial under double jeopardy clause. It reflected the fact that under the relevant law, the jury had not returned a valid verdict. Only the actual receipt and recording of the verdict constitutes a final verdict. The court reasoned that absent these conditions, it cannot be concluded the jury acted on their view that the prosecution had failed to prove their case as required to establish under the relevant law. It rejected petitioner's contention that the formalities of valid verdicts should not prevent acquittal votes from taking effect. According to the court, requiring a jury to publicly affirm their verdict in open court serves a vital purpose. It ensures the verdict agreed upon in private truly reflects unanimous and deliberate judgment, which, fair enough. That's a valid thing to say. The Supreme Judicial Court went on to hold the trial judge did not abuse discretion in denying petitioner's request for the post-trial inquiry. It found because no verdict was announced as required, a post-trial voir dire would not change the outcome of defendant's first trial. Yeah, there's nothing to do a post-verdict inquiry about because it has no legal impact. There's no reason to do it. The court reasoned petitioner was not entitled to the inquiry because jurors' affidavits do not indicate exposure to extraneous matters or jury bias, and there was no suggestion the failure was due to a clerical error which would have been supported under the relevant law. The inquiry therefore inappropriately required probing the content of jury deliberations and would do so well after they became susceptible to outside influences. In the meantime, the trial judge sent for retrial. As to the procedural history, on February the 18th of 2025, petitioner filed a petition for writ of habeas corpus under 28 U.S.C. 2241 in this court. That same day, the court issued an expedited briefing and hearing scheduling in light of the imminent retrial date. Defendants submitted an opposition brief on February 26 and court oral arguments on March the 5th of 2025. For the following reasons, the petition is denied. All right. There are two threshold questions the court must address before turning to the merits: whether it has jurisdiction to consider the habeas, and if so, whether it must abstain. So as I told you, abstention doctrine, right? It's like I do know what I'm talking about sometimes. Like when I tell you these things, like abstention doctrine, I'm like, they should abstain. And the trial court's like, and the court's like, maybe we should abstain. They're going to at least think about it. They're going to at least think about abstaining. It's like, maybe we should abstain. They're going to at least think about it. So is that the reason? Probably not, but let's read on. A U.S. district judge may issue a writ of habeas corpus for a person in custody in violation of the Constitution or laws or treaties of the United States. A person on pretrial release is considered to be in custody and may petition for habeas relief if that custody violates federal law. Ordinarily, a person in custody is in custody pursuant to the judgment of state court or in custody under sentence of a court established by an act of Congress. Because a person on pretrial release falls in either of these categories, any habeas petition filed by such a person must be brought under 22. Must be reached under 2241. The petitioner here is therefore filed under the correct statute. A state defendant who is released pending trial must contend with the requirements of exhaustion doctrine if she seeks habeas corpus relief in the federal courts. Nonetheless, a petitioner claiming violation of due property clause, due double jeopardy clause, need not stand trial a second time to exhaust state remedies. Instead, she must take her claim that she should not be tried as far again as she can in state courts. Here, petitioner moved to dismiss count 1 and 3 of the indictment based on her double jeopardy claim and appealed the denial of that motion to the Massachusetts Supreme Judicial Court, which denied the claim. Thus, she has exhausted her state court remedies for the violation and the matter is ripe. Accordingly, we have jurisdiction. Yeah, that was not the problem. The ripeness of the issue was not the problem. I never argued the issue was not ripe. It is ripe, but how about abstention? The primary relief petitioner seeks is release from state custody and declaration that retrial on counts 1 and 3, and possibly even 2 for that matter, would violate the double jeopardy clause. In effect, she seeks a permanent stay of her state prosecution. That request for relief potentially conflicts the policy that, except in extraordinary circumstances where danger of irreparable loss is both great and immediate, federal courts should abstain from enjoying state court proceedings to that effect, and citing Younger, which this was a case I cited explicitly when I discussed it on Melanie's stream. I started with Younger. And when I talked about this on Melanie's stream. It's like, there's a reason I started with Younger. It's like, yeah. And like, there's been a whole bunch of cases even since then. But like, yeah, Younger is sort of where this starts, this principle. By statute, a court considering a habeas petition may, before final judgment or after final judgment of discharge, stay any proceeding against the person detained by or under the authority for the state or in any matter involved in a habeas corpus proceeding. Nevertheless, the power to enjoin state proceedings must be exercised sparingly, even where permitted. See, for example, Younger, requiring extension based on absence of factors necessary under equitable principles, assuming the intervention was permitted. So again, not something we're looking to do. Separate sovereigns and all that. A federal court must generally abstain from acting if the requested relief would interfere with an ongoing state judicial proceeding that implicates an important state interest and that provides an adequate opportunity for the federal plaintiff to advance their challenge, which that last element may be a little bit sketchier. But if there's a showing of bad faith, harassment, or some sort of extraordinary circumstance that would make abstention appropriate, a federal court may enjoin or effectively enjoin an ongoing state proceeding. A party may establish extraordinary circumstances that justify such an injunction by showing they'll suffer a great and immediate irreparable injury if the staying proceeding goes forward. In a typical case, a colorable, which means plausible, a colorable double jeopardy claim satisfies irreparable injury because the requirement that the defendant run the entire gauntlet of state proceedings, including retrial, prior to consideration of his claim in federal court, would require him to sacrifice double jeopardy. Here, the petitioner makes a colorable double jeopardy claim. If she's ultimately acquitted on counts 1 and 3, or if a conviction on those counts is ultimately overturned on double jeopardy grounds, she'll have suffered irreparable injury. The court will therefore not abstain. And I said I didn't think they would abstain. I didn't think that was the most likely thing. I thought it was plausible, but I didn't think they'd do it. The federal court doesn't do it. So far, the federal court and I are tracking. We are tracking. Were there any questions so far in chat? Because I didn't see any super chats or anything that came through. So there doesn't appear to be anything, so let's press on. As to C, double jeopardy. Under the Fifth, and then there's a footnote, which I'll read this. It's true that in one instance, the First Circuit applied abstention doctrine in habeas alleging double jeopardy. There, the alleged violation did not establish irreparable injury because of the unique jurisdictional posture. The petitioner there was a minor less than a year shy of her 18th birthday, who was to stand trial for manslaughter if the murder charge against her were dropped on double jeopardy clause grounds and could not remain in state custody after she turned 18. The Court of Appeals concludes she'll suffer no injury from the retrial of the murder count if the manslaughter is subsequently found to be the only permissible charge. However, the court also affirmed the principle in ordinary circumstance the mere possibility of retrial. So, like, she doesn't bear a burden of being tried on murder because even if manslaughter is only the thing that's found, we can reduce the murder to manslaughter and call it a day. So you didn't suffer any prejudice. All right. Under the 5th and 14th Amendments, no person shall be subject to the same offense be twice put in jeopardy for life or limb. The rights against protections against a state prosecution for the same offense after acquittal, against the second prosecution for the same offense after conviction, and against multiple punishments for the same offense. Here, petitioner contends the double jeopardy clause precludes retrial on counts 1 and 2 for 2 reasons. Because the trial judge improperly declared a mistrial, and because she was actually acquitted. Number 2, I don't see. Number 1, more promising. Alternatively, she seeks an order providing for voir dire of the jurors ascertained to vote to acquit. All right. Whether the trial judge improperly declared a mistrial. A trial judge may declare a mistrial in a criminal case without implicating the protections of a double jeopardy clause whenever, taking all circumstances into consideration, there's a manifest necessity. And then subsequent to that, the Supreme Court clarified that manifest necessity is not to be taken literally, and a mistrial is appropriate when there's a high degree of necessity. Cute. A mistrial premised on a trial judge's belief that the jury is unable to reach a verdict has long been considered a classic base for proper mistrial. The decision whether to grant a mistrial is reserved to the broad discretion of a trial judge, citing some really early cases in U.S. Supreme Court history. Furthermore, the trial judge's discretion to declare a mistrial when he considers the jury deadlocked is accorded great deference to the reviewing court. The justification for deference is the trial judge is in the best position to assess all the factors which must be taken into consideration in making a necessary discretionary determination whether the jury will be able to reach a just verdict if it continues to deliberate. In the absence of the deference, trial judges might otherwise employ coercive means to break apparent deadlocks, thereby creating significant risk The verdict may result from pressures inherent to the situation rather than consider judgment of all jurors. The Supreme Judicial Court has expressly declined to require mechanical application of any rigid formula. This is the U.S. Supreme Court. There is no rigid formula, and I think that's correct. Even though that was on a habeas review, I still think that's the correct statement of the federal law. There is no mechanical review. There is no mechanical application. There's no one thing you can necessarily point to say manifest necessity. Nothing in particular is necessarily required by the judge. Nothing is particularly required. If they don't do anything, that might be a problem, but they're not necessarily required to do any particular thing. Similarly, the First Circuit has held trial judges are not required to take specific steps or make specific findings before concluding a jury is deadlocked. Rather, judges exercise sound discretion to declare a mistrial based on deadlock as long as they take some step to ensure the trial judge is unable to reach a verdict before discharging it. Okay. Here, there was manifest necessity for declaration of the mistrial based on jury's deadlock, and the trial court did not abuse discretion. So, interesting enough, they're going to say that the manifest necessity thing doesn't even apply. So, the trial judge and I might depart a bit here on this issue. So, there seems to be like we're doing a naked application of law, maybe. And so, if we're doing a naked application of law and we're still not finding manifest necessity, the trial judge and I might disagree. It's not like a really sharp disagreement, though. It's not like I think the judge is out of their mind. It's just I think I might have come the other way on the issue. I think I might have broken the other way. And it's not like the judge is unreasonable for doing so. It's just I think I would have gone the other way. In memorandum of decision, the trial judge, she had no doubt based on the jury notes, the jury was unable to reach unanimous verdict. Nothing in the jury's 3 notes, she found indicated agreement on any of the charges or any of an inkling of agreement, notwithstanding the care that went into writing the notes and how articulately they expressed jurors' disagreement. Once the jury reported deadlock for the 3rd time, Massachusetts law prohibited the jury from ordering a jury to continue deliberations without consent. She concluded it was clear the juries would not consent to continuing their deliberations after she sent the 3rd note. The Supreme Judicial Court similarly concluded the jury clearly stated during deliberation they had not reached unanimous verdict on any of the charges and could not do so. The 1st and 2nd notes provide no indication of partial consensus, and the 3rd note plainly implied the opposite. In short, the record before the trial judge suggests a complete deadlock. This court sees no basis to conclude the trial judge's discretion to declare a mistrial was incorrect or improper. To begin, the relevant inquiry is not confined to the brief interval of the time between the receipt of the note and the trial judge's declaration of mistrial. If you can find it somewhere else, fair enough. By that point, the jury had deliberated for more than nearly 30 hours and sent 3 notes to the court indicating they were deadlocked, the latter 2 making that point with considerable emphasis. The trial judge held 2 conferences with counsel to discuss how best to respond, during which both counsel agreed the jury was at an impasse. At the second conference, the judge gave the Turi Rodriguez instruction. In short, the decision to declare a mistrial was a product of a multi-day discussion between counsel and court. Under the circumstances, the judge cannot have been acted precipitously and without adequate time for reflection. And although they don't quite connect 2 and 2 together, you could read these 2 sentences as implying what I've been saying for a long time, that basically the Tui Rodriguez charge was sufficient notice that the judge was considering mistrial, because it's like the only thing left. So although it doesn't actually say that in that many words, you could read these 2 sentences as implying it, which, I was like, yeah, that might be sufficient. So if that's where we're coming from, that, it was floated and there was no surprise, that makes sense. Nor did the trial judge fail to provide defense an opportunity to be heard. The judge solicited counsel's view after 1st and 2nd notes. By the time of the 2nd note, if not earlier, it should have been obvious to all parties that mistrial was highly likely. Once you give that instruction, for sure. As for counsel's opportunity to respond to the 3rd note, it's true the span of time was relatively brief between the point of time the trial judge advised counsel the jury was at an impasse and the point she declared a mistrial. But it was not so brief they could not have asked to be heard. So it sounds like consent is back on the menu, boys. Yeah. Like the 30 seconds was not so brief, particularly because the instruction was given. 30 seconds was an adequate opportunity to object. That's what I said. So the trial judge and I seem to be of accord, as best as I can tell. Petitioner also contends the trial judge improperly failed to consider alternatives. The trial judge did in fact consider alternatives in response to the first and second note and concluded after giving the second note to give the Tui Rodriguez charge. Okay, I mean, that's a little thinner than my taste than I would like based on my reading of the First Circuit law, but it's not a wholly implausible point of view. After the third note, which again emphatically indicated the jury was at a deadlock, Massachusetts law required to discharge the jury unless it consented. The judge reasonably determined on a circumstance it would not consent. That much I have no problem with. So, yeah. Okay, nothing more was required as a matter of federal constitutional law before the trial judge could fairly conclude the jury was genuinely deadlocked and should be discharged. Now, the reasoning of the judge here is not as clean as I would like it. Because it's a little bit not as clean on this issue as I would like to understand. Because if the judge was basically saying that deadlock instruction, though, I'd be like, yes, that deadlock instruction, right? I'd be like, yeah, that's the thing, right? But the judge isn't saying that. And my reading of the First Circuit law on this point, I think on balance, seems to go the other way, unless the judge wanted to do it for that reason, because the First Circuit law didn't seem to really contemplate that particular point. So that would be like a point where it's like, oh, the judge is going to do this because of this reason, which would make sense. But if we're just operating based on First Circuit law without that thing, I think maybe I would have gone the other way. Again, this is not like a dramatic departure. This is two lawyers having a friendly disagreement, right? This is not like, you're out of your mind. I can't imagine why you'd say that. This is reprehensible. I will bury you. You know, it's nothing like that. We're just having a very friendly difference on basically where's the strike zone, right? We're having a very friendly discussion on exactly where's the strike zone. And it's like, your view is reasonable. No, your view is reasonable. It's like, we're both reasonable, right? So that kind of thing. And thank you, by the way, for the 432 of you who are joining and spending some time with me. Okay. In particular, a trial judge was not required to inquire about a partial verdict or poll the jury. They're not required to do that. As the Supreme Judicial Court noted, to make further inquiry would make substantial possibility of a coerced verdict. In summary, the trial judge took appropriate steps before determining the jury was genuinely deadlocked. The evidence the jury was at an unresolvable impasse was substantial, and the trial judge exercised a broad discretion, made a well-grounded decision to declare mistrial, a decision that's entitled to great deference. I don't hate it. I don't hate it. I don't hate it. I mean, it is an abuse of discretion analysis, typically. I don't hate it. So, yeah. Accordingly, there's manifest necessity. Petitioner may be tried again with violating their rights. And again, interestingly, no explicit discussion on the issue of consent. We're just going to go on to whether the jury acquitted the petitioner. No explicit discussion of the issue of consent. Okay. I mean, that's what we're rolling. Interesting. All right. Whether the jury acquitted the petitioner, this answer is clearly no. Petitioner further contends she was actually acquitted by the juries to count 1 and 3 and therefore cannot be tried again. It has long been settled under the Fifth Amendment that a verdict of acquittal is final, ending defendant's jeopardy as a bar to subsequent prosecution for the same offense. The double jeopardy clause recognizes an event as acquittal when there's been any ruling that the prosecution's proof is insufficient to establish criminal liability for an offense. It is also well established that whether an acquittal has occurred for the purpose of the double jeopardy clause is a question of federal, not state law, because of course it is, because it's a federal law. The analysis does not depend on state law labels and state's characterization. Right, because the label's not the thing. Nonetheless, state law remains relevant. The ultimate question is whether the double jeopardy clause recognizes an event as an acquittal. In making that determination, we ask, given the operation of state law, there's been any ruling the prosecution's proof is insufficient to establish a criminal liability for the offense. Fair enough. A ruling of insufficient proof does not require a jury verdict. Right. A judge may direct a verdict of acquittal or overturn a conviction based on insufficient evidence. The critical question is whether there was such a ruling. Here, the Supreme Judicial Court summarize what constitutes a valid verdict under the operation of relevant state law. The fundamental requirement for a jury's issuance of a verdict in a criminal case are set forth in the law. Pursuant to the rule, a valid jury verdict must be unanimous and returned by the jury to the judge in open court. Our case law confirms a criminal verdict is effective only when agreed by jurors in open court. In other words, the distinction between informal agreement on a verdict and actual return, receipt, and recording of a verdict in open court is essential. Only the latter constitutes a final verdict to the jury on the criminal charge. We've constantly reaffirmed this law and standing distinction throughout the jurisprudence. In other words, it ain't final till it's final, baby. It ain't final till it's final. The jury can change its mind right up to the time they're being polled by the judge and be like, is this your verdict? And they can say no. And they can change their mind right up until the very end. Until the end, it ain't final. So, yeah. The Supreme Judicial Court concluded the jury here did not render a valid verdict under Massachusetts law. Writing, far from an affirmation in open court of unanimous agreement on counts 1 and 3, these notes clearly reflect a lack of consensus on the charges. Even if the jury's deadlock pertains specifically to count 2, their note made no such distinction, nor they indicate any verdict would be returned to the judge in open court as required by relevant law. Petitioners agreed to concede as much. Thus, in the absence of a valid verdict under state law, she must point to some other ruling. The prosecution's proof is insufficient to establish criminal liability. I knew this was not going to work. I knew this was not going to work. This was not going to be the grounds that this turned on. This was not going to be the grounds this turned on, right? This was going to turn on the issue of manifest necessity / consent. That's what it was going to turn on. Not this. This argument had no, I was like, there's no way the court is going to go down this path. That doesn't strike me as at all what's going to happen. So if they had gone down this path, I would have been amazed. Unfortunately, I'm not amazed, even though I am amazed sometimes, but I'm not amazed today. Petitioner has not done so. Counsel appointed no Kate from any jurisdiction. See, I told you precedence matters, man. It's like, it matters, man. It matters. I told you, precedence matters, right? If you can't find any case, that's right. It's like one of you guys in the prior chat was like, but this case touches the Constitution. I'm like, yeah, but you've gone off all the way from the ideal of I have a one-to-one case, and you've gone all the way from that ideal as far as you can possibly go. You've gone to the outermost orbit of there's a Fifth Amendment. And that's not a great position to be in. That's not a great position to be in. That sucks. It's like, that's a problem, man. So counsel has pointed no case from any jurisdiction. And it's like, I'm not going to be the first, in which a private, unreported, and unrecorded vote of a jury was deemed to be a ruling capable of terminating jeopardy. In fact, the Supreme Court has held it's not sufficient for the jury, foreperson of a jury to report in open court the jury has voted to acquit on certain counts. See Bluford. I told you Bluford was going to pop up. In Bluford, the defendant was tried in Arkansas State Court for capital murder, which include lesser included offenses of first-degree murder, manslaughter, and negligent homicide. After a period of deliberation, the foreperson reported the jury was hopelessly deadlocked. The court then asked the foreperson to disclose the jury's vote on each offense. The foreperson reported that the jury had voted unanimously against capital murder, voted unanimously against first-degree murder, was deadlocked in manslaughter, and had not voted on negligent homicide. The court gave the jury an Allen charge and instructed the jury to resume deliberations. When the jury returned a half hour later and reported they're still deadlocked, the court declared a mistrial. The state then sought to retrial the defendant on all charges. So we're going through the history of Bluford, right? In Bluford, the court actually asked, what are your verdicts so far? And they're like, oh, we've acquitted on the capital murder, or we're not guilty on capital murder. They said that in open court in Bluford. They said in open court, we're 12-0 on the capital murder, but we're a little bit hung on manslaughter. And the judge said, not good enough. Keep going. Not good enough. Keep going. Right? The state then, when the jury came back, they reported they were deadlocked on everything. So they went from we're 12-0 to acquit to we're now deadlocked across the board. That's what happened. The state then sought to retry the defendant. He moved to dismiss capital murder and first-degree murder and double jeopardy. The trial court denied the motion. Arkansas Supreme Court affirmed. The Supreme Court of the United States also affirms. The Supreme Court concluded the defendant had not been acquitted, and therefore double jeopardy did not bar the trial as to all charges. Bluford's primary submission is he cannot be retried for capital and first-degree murder because the jury actually acquitted him. The Arkansas Supreme Court noted, and Bluford acknowledges, that no formal judgment of acquittal was entered. Thank you, Sweet Leaf, for being a member for 2 months. But none was necessary, Bluford maintains, because acquittal is a matter of substance, not form. Bluford contends that despite the absence of any formal verdict, a jury's announcement constitutes acquittal if it actually represents a resolution of some or all the factual elements of the offense charged. Here, according to Bluford, the 4 persons announcement of the jury unanimous votes on capital and first-degree murder represented just that, a resolution of some or all the elements. The United States Supreme Court disagrees, concluding that the 4 persons report was not a final resolution of anything. Supreme Court of the United States writes, when the 4-person told the court how the jury had voted on each offense, the jury's deliberations had not yet concluded. The jurors, in fact, went back to the jury room to deliberate even further, even after the 4-person had delivered their partial report. When they emerged a half hour later, the 4-person stated only they were unable to reach a verdict. She gave no indications whether it was still the case that all 12 believed they were not guilty of capital or first-degree murder, the 9 believed they were guilty of manslaughter, or a vote had not been taken. In fact, deliberations continued after the report to apprise the report of finality necessary. So apparently they just like, we're unable to figure it out. And I was under the impression they had explicitly announced that they were hung, but even then they didn't announce they were explicitly hung. So the jury had said, we're 12-0 to acquit. And then it's like, try harder. And the jury says, well, we still can't make up our mind. That sounds pretty close to Karen Reed, to be honest. That sounds really close. The court concluded it was therefore possible for a Bluford jury to revisit the offenses of capital and first-degree murder, notwithstanding the earlier vote. And because of that possibility, the 4-persons report prior to end of deliberations lacked the finality necessary to amount to acquittal of those offenses, quite apart from any requirement the formal verdict be returned or entered. Here, even assuming the jury did take a vote to acquit petitioner on counts 1 and 3, there's no basis to conclude that such agreement was final. Very fair, very fair. And unlike Bluford, any such agreement was not reported in open court or in the presence of other jurors, casting even further doubts as to the finality. Petitioner seeks to distinguish Bluford on the ground that the post-trial jury statements here reflect the jury's positions at the end of deliberations, and therefore there was no real possibility the jury might change his or her mind. But those post-trial statements do not actually indicate when the relevant vote was taken, or they actually reflect a final conclusive verdict on acquittal by all 12 jurors. That's parsing it a little thin for my taste, to be honest. I don't think you have to parse it that thin. So I don't think I would write it that way. I don't think I agree with this. That's being overly pedantic in my view. And I don't think it's required to come to the decision, so I wouldn't say it. It's not necessary for me to make the decision, so why say it? And they certainly did not foreclose the possibility that relevant votes were based on a preliminary discussion or straw poll. In short, any jury verdict here was not final as required by Bluford. It was not actual return, receipt, and recording of a verdict in open court as required under Massachusetts law. And there's no basis in fact or law to conclude that ruling capable of terminating double jeopardy. Accordingly, as a matter of federal constitutional law, petitioner is not actually acquitted. Yeah, I mean, I would have written this differently. I would have just simply said we're a federal court under federal law. And even if the trial judge had literally brought them in as a matter of federal law and said, what are your verdicts? And the jury had said not guilty on 1 and 3, were undecided as to 2. As to federal law, I think you could just simply say, well, that's not good enough. And that's the basis which I would have made the ruling, I think, rather than this reasoning. But, we can't always get what we want. Sometimes judges think about things differently. I mean, we're coming out to the same result, but for different reasons. So in some level, it's a bit academic. It's like the judge is like, I like this reason best. And I'm over here like, I don't really like that reason. I like this other reason best. But we agree as to the result? Yeah, we agree as to the result. It's like, okay, we agree. So, good enough. Good enough. We agree. Whether a post-trial voir dire of jurors is appropriate. Finally, alternatively, petitioner requests post-trial voir dire of individual jurors. There's no reason to do this. It doesn't make any sense. The Supreme Judicial Court rejected that request, concluding inquiry would contravene the rules. There's a threshold question as to whether this court has legal authority to conduct such a voir dire. As a general matter, the statutory framework for habeas petitions contemplates the taking of evidence. Specifically, Section 2243 provides the court shall summarily hear and decide the facts underlying the petition. Section 2246 further provides on application for writ of habeas corpus, evidence may be taken orally or by deposition or in discretion of the judge by affidavit. And when the federal petitioner files a habeas under 2255, challenging her confinement, the statute expressly authorizes the court to make findings of fact to determine whether the claim has merit. However, in a petition filed by a state petitioner under 2254, challenging his or her state confinement, a federal court has more limited authority. The posture matters. The posture matters. In such a proceeding, a determination of the factual issue made by the state court shall be presumed to be correct, subject to rebuttal. If there have been no state court factual findings supporting the claim, the petitioner is entitled to an evidentiary hearing only if the claim relies on a retroactive rule of constitutional law or a factual predicate not discoverable through due diligence, and the facts petitioner seeks to adduce would show there's no reasonable fact finder would have found the applicant guilty. Petitioner here is not challenging a federal sentence, nor a state court judgment, so our petitioner is not brought under either 2255 or 2254. Instead, they're challenging under 2241. In one respect, the ability of a federal court to conclude a fact-finding inquiry in connection with 2241 is clearly limited. The federal court must give deference to any findings of fact made by the state court. I've been muted the whole time. I'm sorry. I was muted. How long have I been muted? Has it been a long time? How long was I muted? How far do I have to go back? I was going to sneeze and I hit the button. How long? 30 seconds? I could go back to the paragraph? No? Okay, thank God. Yeah, 30. Yeah, just a minute or so, not long. Well, just a few minutes. Yeah, I'll just go back up to here. Counsel for petitioner has not pointed to any case from any court where a federal court concerning 2241 petitioner has either undertaken its own voir dire of a state court proceeding or ordered a state court to do the same. Here, either approach is fraught with potential problems. To begin with, an injunction directing a state court to conduct a voir dire of the former jurors would implicate substantial current concerns of federalism and comity. Fair. Let me just ask you what the last thing you heard before I was muted is. What was the last thing you heard? And I'll go back and reread it and express. Because I don't want you guys to miss it. That's not what I'm here for. So, how far back do I need to go? I'll wait for you guys to type. I'm still waiting. Just keep going? Okay. The general grant of fact-finding authority under 2243 and 2246 would seem to permit, we read that one. Okay. To begin with, an injunction directing a state court to conduct a voir dire of former jurors would implicate federal concerns. Yeah, the federalism, and see, for example, Younger. So basically, we're citing abstention doctrine, basically, at this point, to not do that. Right? We're citing abstention doctrine to not do that. While these concerns may be somewhat mitigated if the court itself conducts voir dire, such a process would nonetheless present a substantial intrusion by a federal court into the function of a state judiciary. For example, at a minimum, this court would have to issue an order directing the state court to reduce the impounded juror list. Such a voir dire should be taken, if at all, under only extraordinary circumstances and even within great circumspection and care. I appreciate this. I appreciate this language. Furthermore, the voir dire petitioner proposes would inevitably require a detailed inquiry into jury deliberations. Petitioner contends the inquiry could be limited to a simple yes or no question as to any votes the jury may have been taken as to declaration of mistrial. But surely more would have been required. And I've said this before too. I was like, the defense is fooling themselves. They're fooling themselves that they think this is a simple yes or no. That is not true, man. That is not true. A voir dire would have served little to no purpose unless it established the jury took a unanimous and conclusive vote of acquittal on one or more counts. To make such a finding, it would be necessary to ascertain when the votes were taken and what each juror said and thought at the time of the vote. How many votes were taken? Were they strawed votes or otherwise preliminary or tentative? Was the timing of those votes in connections with the notes? What, if anything, did the jurors say to each other about the notes? Did the votes reflect compromise? Was a possible compromise discussed? What are the mental processes? Did the jury have private reservations? How can any such votes be reconciled with the jury statements they were deadlocked on the charges? Why are the jury affidavits inconsistent? So the trial judge also is not buying the defense's bullshit when they said you can just ask one question, though. Yeah, the trial judge and I are both calling bullshit. Now, I'm not sure I necessarily agree that these questions would be required. I'm not sure I agree with these questions being the ones required. But I do agree with the trial judge calling bullshit on the defense. Bullshit. We could just do this in one. Bullshit. We can just ask one question. There is no way that that's going to happen. Murphy's Law and all that is like, there is no way on this goddamn earth that it's going to be one and done. Yeah, the trial judge and I are both calling bullshit, so that's fine. Nor would the inquiries be limited to deliberations and votes inside the jury room. Because the events in question happened more than 8 months ago, it'd also be necessary to inquire into matters such as potential pressures on the jury since the conclusion of trial and the effects of any such pressure on their testimony. These are hardly hypothetical concerns, given the intense public focus on these jurors and the expressly voiced concerns for their private and even physical safety. As any voir dire of the nature would at a minimum involve considerable complexities and lead to extended delays. But even assuming the many practical issues of voir dire could be resolved, and even putting federalism and comedy issues to one side, there is a more substantial problem with the proposal. It runs directly contrary to long-established principles that generally prohibit any examination of juror deliberations. Well, again, this is not the rationale I would pick it. This is not the rationale. My rationale is it doesn't matter. That's my rationale. It's like, there's no reason to do it because it doesn't matter. You know, you just told me that incidentally earlier in your own opinion. You told me about like, it has to be announced in public and all the rest of it. You told me that. You already told me it doesn't matter. So you're going to a lot of length to tell me other reasons why you're not doing this, when you could just be like, read what I wrote above, people. You know, I already told you that I agreed about this having to be read in open court and all that, and obviously it wasn't done. So there's no reason to do it because it doesn't matter. So that's my conclusion. It's simpler. $10 from G6585. I'm still confused how destruction of evidence, as well as the cops working for Alberts to cover up things, hasn't nulled the case. None of those issues are present in this case. And none of those issues were raised to the Supreme Court relating to the double jeopardy. So they have not nulled the case because those issues have not been raised at the Supreme Judicial Court nor in this opinion. That's why they're not being mentioned, because they weren't talked about. But thank you for your super chat. And same thing with Brady. Brady violations weren't brought up to the Supreme Judicial Court. Brady violations weren't part of this lawsuit. Same exact reason. That no one asked. No one asked. And it's not even necessarily clear they can ask, but they didn't ask in any event. So the court's answering the question that was asked. That's what they do. It's just that simple. I don't think Karen has a very good lawyer. I think they have an exceptional lawyer. I'm not even clear that they can ask. And incidentally, the typical remedy for Brady violations is a new trial, which we're already doing anyway. So, like, even if they had done the Brady thing, the typical remedy is a new trial. So we're already doing a new trial. So you're already getting the remedy you would have gotten anyway. So it's kind of moot. So I mean, that's that. I mean, that's how that goes. Not in the Baldwin case. Well, the Baldwin is a different posture because the Baldwin thing happened while the case was ongoing. It happened in the middle of the trial. It's a different posture. It's a different posture. So in cases where people have been convicted and the defense has argued Brady and the courts have agreed, the typical remedy is a new trial. In Baldwin, that remedy didn't work because they were already in the middle of the trial. And so that posture was different. Also, incidentally, I don't think the trial judge was necessarily required to dismiss with prejudice. I don't think the trial judge was required to do that. They certainly could have. It was certainly a valid choice. but I don't think they necessarily were required to. It was an extreme remedy, as even the trial judge, basically, when they announced the decision, said it's an extreme remedy. So the Baldwin posture is different than here. We're not in the middle of trial. Trial hasn't started yet. So it's a different posture. What happens next? The trial does on April 1st. Well, there's a potential for appeal. We'll discuss that, but basically the trial does. All right, where are we? Any voir dire of that nature would at a minimum involve considerable complexities and lead to extended delays. The starting point for the analysis is the federal rules of evidence. The rule provides as follows. During an inquiry into the validity of a verdict or indictment, a juror may not testify about any statement made or incident that occurred during the jury's deliberation, the effect of anything on the juror or another juror's vote, or any juror mental process concerning the jury indictment. The court may not receive a juror's affidavit or evidence concerning these matters. The rule codified longstanding common law principles designed to protect freedom of jury deliberations, protections against jury harassment, and finality of verdicts. The Supreme Court has noted that prohibitions set out in the rule derive from longstanding common rule supported by substantial policy considerations. Jurors would be harassed and beset by a defeated party in efforts to secure from them evidence of facts which might establish misconduct sufficient to set aside a verdict. If evidence that thus secured could thus be used, the result would be to make what was intended to be private deliberation the constant subject of public investigation to destruction of all frankness and freedom of discussion, not invalid issues to be sure. The deference is not absolute. Yeah, I mean, it is not absolute. Yeah. There's very little absolute in law. We discussed that many times. It's true that Rule 606 does not literally apply here because the jury did not actually render a verdict. Nonetheless, the same policy considerations concerning the freedom of jury deliberations and protection of jurors against harassment are unquestionably implicated in the circumstance of this case. In fact, they apply with unusual force. This is a highly sensationalized prosecution that's been the subject of exceptional public scrutiny, not only locally, but nationally. For a number of reasons, it's also proved to be unusually divisive. There's a strong likelihood that jurors would be subject to harassment, public pressure, and social coercion were the court to order a post-trial voir dire that exposes their viewpoints and votes at some length. More than 8 months after the conclusion of the trial, the jurors' willingness to speak honestly about their deliberations would sure be compromised. Even the policy underlying the rule that favors finality is implicated, if only by analogy. The jury reported a deadlock, culminating in the jury note saying the jury was starkly divided as to whether the Commonwealth had proved the necessary elements of the charges, leading illustrably to a substantial, if not final, legal consequence, the declaration of mistrial and termination of the first trial. For all those reasons, the court concludes that for federal court voir dire, the state jurors of voir dire necessarily subject their private deliberations to intense public scrutiny is probably unlawful and certainly ill-advised. But in any event, under the circumstances presented here, the court concludes it's not necessary to reach the issue here. Yeah, because it doesn't matter. Right? It's like, finally, we got to it doesn't matter. But in any event, it concludes it's not necessary because I don't need it. So this is a bit frustrating. I'm like, why did we just spend all that time talking about it? Because it's like it doesn't matter anyway. It's like the court's about to say what I about to said. It's like, why did we spend all this verbiage saying this? Because I didn't need to. I didn't need to say it because it wouldn't have mattered anyway. It wouldn't have mattered anyway. So the judge just wanted to opine for a couple pages for some random musings. Dicta indeed, my friends. Big time dicta. Big dicta energy. 100%. Even assuming the post-trial voir dire elicited evidence strongly favorable to the petitioner, such as attestation from each juror, the jury voted unanimously to acquit, it would still fail. As noted, an acquittal requires a ruling the prosecution's proof is insufficient to establish criminal liability. A private, unreported, unrecorded jury verdict is not a ruling and therefore not an acquittal. At the very least, such a ruling requires finality, and public affirmation of a verdict is part of what makes it final rather than provisional. The opportunity for a single juror to change its mind is sufficient to undermine finality. As such, an event does not constitute acquittal, therefore there was no ruling. For the foregoing reasons, the writ of habeas corpus is denied. Okay. And then we have a little bit more. Memorandum in motion for a certificate of appealability. Can I please appeal, district judge? I'd like to appeal. Can I please appeal? Let's find out if we can appeal. This is a petition for writ of habeas corpus under the relevant law. Petitioner Karen Reed challenges her continued prosecution in Massachusetts State Court after a declaration of mistrial on the ground that it violates her rights. She's under indictment for second-degree murder and 2 other charges. Her first trial, those charges ended in a mistrial. Her petition presents 4 questions. Whether the jury's unanimous conclusion following the trial is not guilty on counts 1 and 3 constitutes an acquittal. Whether alternatively the defense is entitled to a post-verdict judicial inquiry to determine whether the evidence supports the jury's representation. Whether re-prosecution is independently barred because there's no manifest necessity to declare a mistrial. And assuming arguendo, the court found consent to mistrial where defense personal consent was required. And incidentally, they still did not issue the issue of consent for some reason. On March the 13th of 2025, the court denied the habeas petition in its entirety, ruling against petitioner on the first 3 grounds and determining it did not need to reach the 4th ground. So it's like, I'm not going to discuss the consent issue either. No one wants to discuss the consent issue. I'm not sure why, but no one wants to touch the consent issue. So whatever. To appeal a final order in a habeas proceeding constitutes the validity of state custody. A petitioner must first obtain a certificate of appealability from either the circuit justice or a district judge. A certificate of appealability will issue only if the petitioner has made a substantial showing of a denial of right. The standard is satisfied by demonstrating that jurists of reason could disagree with the district court's resolution of the constitutional claims, or that jurists could conclude the issues presented are adequate enough to deserve encouragement to proceed further. Thank you, $5 from Bird. Petitioner has made this substantial showing. Accordingly, certificate of appealability is granted. So she can appeal to the First Circuit Court of Appeals. So we're off to appeal, people, I presume. We're off to appeal, and a very hasty decision from the Court of Appeals for the First Circuit, I would imagine, maybe with or without oral argument because of the time frame. Because time is so tight on this, it would not surprise me if the First Circuit makes a decision based on briefing on an expedited schedule. Even if it's basically a 1 sentence basically saying we agree, which probably is the most likely thing to have happen. The most likely thing for the Court of Appeals to do is basically a 1 sentence opinion that says we're good. That's probably all that's going to happen. But they have the right to ask. So probably a quick file, quick turnaround, quick briefing, and probably a quick 1 sentence decision that says we're good. It's probably what's going to happen. But that's what we're doing. All right, so all those things. And we still have one more thing. We have a motion for reconsideration on the issue of excluded testimony, on the issue to exclude the testimony of Crosby. So are there anything, does anyone have any discussion on the habeas before I continue? Or are we good? How are we feeling, chat? Can I briefly recap the first principle? Well, you have to be more specific. What's the first principle? Depending on where you're measuring from, there are a number of first principles, so you have to clarify which one. It's pretty straightforward. Fair enough. Habeas was always a stretch. I agree. Abstention doctrine, the ability to abstain. So there is a case called Ex parte Younger from the U.S. Supreme Court, which is the foundational case in this domain. And of course, there have been many cases since. But basically, long story short, it says that the federal courts should not intervene with ongoing state-level proceedings unless they really have to. We have a federalist system in the United States. The federal government is sovereign. The states are sovereign. And so the federal government doesn't interfere with the state governments unless they really have to, because the states are sovereign and they can do as they can do as they will because they're king. That's what it means to be the sovereign. They're king. And so they don't intervene. They don't intervene unless they really, really have to. And so, they cited the relevant casework, and there's, cases to the contrary. And in this domain, there's specific statutes. So the court did not trigger abstention doctrine. I didn't think they would, but they could have. But it was a non-trivial issue. So all those things. And this is State of Mass versus Karen Reed, Well, strictly speaking, this is Karen Reed versus the court and versus the attorney general. It's a different parties, but yeah. I should think about becoming a law professor. I'd love to be a law professor. That'd be great. I think it'd be awesome to be a law professor. All right, let's read the motions for reconsideration. Now comes the defendant, Karen Reed, and respectfully requests this court reconsider its order denying the motion to exclude the testimony of Crosby. And after such reconsideration, defense requests the court exclude the entirety of the testimony. I mean, the judge's order was like, it was so superficial. It's so conclusory. It was like, it was just annoying, man. It was such a pain in the ass. In an alternative amendment, defendant requests an evidentiary hearing to determine whether the Commonwealth can meet its standard. Defendant should complete its questioning in only half a day. In defining motion to exclude the testimony, the court stated the Commonwealth has satisfied the foundational requirements. The court did not provide any record citation or other record evidence for how the Commonwealth has met its burden to satisfy the 5 foundational requirements, including prominently the methods are reliable. Nor the court addressed the alternative defendants that double hearings should be conducted, not to exclude Crosby outright on the papers alone. The order contrasts with the court order 2 evidentiary hearing of Dr. Russell, a medical that's pretty funny. That is fair. That does show a bit of unequal treatment. That's fair. Nikki says, I'm looking great. Thank you. You can see the progress of my health journey. Thank you. I appreciate it. I picked up my new meds today. Oh, by the way, for those of you who are curious, just a while, because I was doing a whole healthcare stream last night. So I looked into the issue, and my healthcare company, at least on their official formulary, does not recognize obstructive sleep apnea as a valid basis to be prescribed Zepbound. So sorry for the brief detour. So in December of last year, the FDA approved Zepbound, which is typically prescribed for weight loss. They approved it for another label. They approved it for treatment of obstructive sleep apnea in December. And it's like, okay, I have one of those, so I wonder if that can be a qualifying criteria. So I pulled the insurance company's formulary to double check to see if I had misread it, because it's like, I don't remember reading that because I had read it before. It's like, I don't remember reading that. So I pulled it again. I did find it eventually. I had trouble finding it. I did eventually find it, and I pulled it again, and it's not covered. The only grounds they cover is for treatment of diabetes, or for Mounjaro. Actually, for anything. Actually, any of them is the only thing they treat. So Zepbound is not labeled for that, and so they don't recognize it at all. So any of them, and so my insurance companies had just straight not covered. It's not covered for Zepbound at all. So, but I did call my doctor's office and ask that they ask for an exemption using the FDA's approval as a rationale. So I did contact my doctor's office and asked for an exemption. I did pick up the medication today because I was out, and I imagine it's going to take some time anyway. So maybe next month I'll get it for, prescription money if, fate is kind. But I did look. It wasn't that simple. I did read the rule for the first time, and we press on. So another $650 for drugs expended out of my bank account. Exciting. So we'll see. We'll see. I mean, it seemed logical, because I don't know when they wrote the formulary, but it seemed logical that they wrote the formulary without necessarily having particular knowledge of the FDA, because the FDA, it was actually like mid-December too. It wasn't like early December. I think it was mid-December. So I was like, I was just going on the presumption that when they wrote the formulary, they didn't write it with that in mind. Seemed reasonable that there had been basically a change of circumstances that they were unaware of when they wrote the formulary. And so maybe there's therefore a basis to reopen the issue. Seemed plausible, seemed worth a chance. So we'll give it a shot. Yeah, I'm not overly optimistic, by the way, but it seemed worth a chance. Get a prior authorization. This is what I'm talking about. Anita, what do you think I've been talking about for the last 2 minutes? What do you think I've been talking about for the last 2 minutes? And strictly speaking, it's not a prior authorization. Strictly speaking, it's an exception because it's not listed as a prior authorization reason. So first of all, what have we been talking about? Second of all, strictly technically, it's not a prior authorization. Technically, it's an exception because a prior authorization would be, here are the reasons we approve. And it's like, I meet these reasons. That would be a prior authorization. In my case, it's like, here's the reasons we approve. It's like, I don't meet any of those reasons. Would you like to do it anyway? So technically, that's an exception. But that's what we've been talking about for 2 minutes. That's what I'm working on. So we'll see. We'll see. And my doctor did switch me to Zepbound. Not that it makes any difference to me because it's all trisepatide to me. So they did change my prescription from Mounjaro to Zepbound. I presume as part of the effort to get the denial, which then will allow them the basis to the appeal and so forth and so on and all the rest of it. So, good times. Yeah. All right. The court did not provide any citation for the evidence of how it met its burden, nor the court addressed the alternative request the Daubert hearing the court should not exclude out on papers outright. The March 6th order contrasts with the court order 2-day evidentiary hearing of Dr. Murray Russell, a medical doctor with approximately 30 years experience as an emergency medical physician and forensic psychologist. Dr. Russell co-authored peer-reviewed books on dog and fighted wounds and submitted an 11-page report before the hearing, which he documented results. Yeah, that unequal treatment is a whole nother thing, man. That's a funny point. Defendant does not waive and reserves all basis for exclusion, Dr. Crosby stated in the original motion. Yet for efficiency in this reconsidered motion, the defendant focuses on just the factor 4 said in Polk, namely the theory underlying the opinion is reliable. This factor is also known in parlance as the methodology prong. A failure of any one of the 5 foundational factors set forth in Polk compels exclusion of the proffered testimony at issue. The Commonwealth had 4 opportunities to show it can meet the Daubert-Langen method prong. Its written opposition dated February 5th, 17th. The supplemental report of Dr. Crosby, in which he stated the mold aspect of unsupported mold measurements. Thank you very much for the 20 gift memberships. But failed to account for the absence of any requisite overlay in his methodology. Oral arguments on the exclusion motion and listed cases in which Crosby testified in court were submitted to the court on March 6, 2025. In each of these opportunities, the Commonwealth failed to even attempt to show the purported mold measurements employed by Dr. Crosby in opining whether the wounds to the right arm decedent were caused by a dog bite or dog attack generally accepted in the relevant medical or scientific community, or the methodology meets the apt Daubert-Langen factors. Notably, Dr. Crosby has never attempted to make such a showing either. His report is completely bereft of even the mention of satisfaction of general acceptance of his mold measurement methodology or acceptance or satisfaction of Daubert-Langen factors, let alone a showing and meeting them. And he's never submitted an affidavit of support of anything of himself, including his qualifications or documentation of any kind, of how his purported methodology is generally accepted or otherwise reliable with citations to medical or scientific literature. The February 17, 2025 affidavit submitted by Mr. Brennan is likewise of no weight in the inquiry, as he lacks first-hand knowledge or requisite expertise in the subject matter. But even in his affidavit, Mr. Brennan mentions nothing about the satisfaction of the common acceptance precept or Daubert factors. Tellingly, Mr. Brennan merely states in paragraph 7 in a bold conclusion that Dr. Crosby is engaged in a substantial methodology. Substantial does not even begin to satisfy the requirement of mold methodology that Dr. Crosby is supported by evidence of common acceptance in the relevant medical or scientific community or satisfy relevant Daubert factors. Likewise, in its written opposition, the Commonwealth simply stated that Dr. Crosby engaged in a recognized methodology, but wholly failed to state any support for recognition because there is none. Nice. As a result, the Commonwealth has provided the court with no basis on which to conclude the mold measurement of Dr. Crosby is reliable, the prerequisite for satisfying the factor of Daubert. The court cannot satisfy the gatekeeper function by invoking the same conclusory statements as the Commonwealth has invoked here. That is some nice legal burn. That is some nice, absolute legal burn, man. That's some good shit. Case law makes clear the gatekeeping factor of the trial court is especially significant. This is all more so in the light of the seriousness of the charges. As the Massachusetts Guide for Evidence makes clear, it's based on the federal rules of evidence, which maintains the common acceptance test. As a result, federal decisions interpreting the federal rules are particularly instructive. The gatekeeping function of the trial judge under Daubert and Rule 702 precepts is of paramount importance. This is nice. This is very legally argued. As such, the importance of the gatekeeping function cannot be overstated. The Polk-Dalbert-Lanigan analysis is no different, whereas here, the witness in question is stipulated to be a rebuttal witness. The facts and law in Hillinger of District Court, Massachusetts, are quite similar to the instant case and thus compel the same result. Non-precedential, but, still. In Clean Concepts, the court stated that following his response to defendant's proffer of an expert witness, the defendant has not directed the court to any evidence demonstrating that Sower's methods for determining primary purchasing consideration have been tested, subject to peer review, are commonly accepted in the field, or otherwise have scientific validity. Nor has defendant made any attempt to demonstrate that Sower's methods were reliable independently of industry practices. Instead, it simply concluded without citation, support, or further argument that Sower's worked from a reliable survey methodology. That assertion alone, standing enough, is not sufficient to demonstrate the reliability of Sower's methods. The Commonwealth has postured its opposition to defendant's motion to exclude Dr. Crosby almost exactly as defendant did in Clean Concepts. Substitute the conclusory recognized methodology, in this case with a reliable survey methodology parlance in Clean Concepts. Very nice. Very well done. Like in Clean Concepts, the conclusory, unsupported, recognized methodology is insufficient. Moreover, Dr. Crosby does not even assert the methodology is recognized, let alone cite the literature or otherwise for a scientific or medical methodology. She already denied this? She did. It's a motion for reconsideration. And the silence exists in the high-pitched volume of medical and legal literature calling into serious question the reliability of even known methodologies involving forensic odontologists, veterinarians, medical doctors, and medical examiners, all of whom are lacking here with Dr. Crosby. Likewise, the March order does not state any evidence of how or where the purported recognized methodology of Dr. Crosby is generally accepted in the relevant medical or scientific community, nor does the March 6 order analyze any of the 5 factors by tying them to the factors of this case, or otherwise cite support in the record for motion of how the unsupported mold measurement is reliable. Nice burns. Nice burns, man. This is good stuff. Defendant respectfully submits this court has performed the entirety of the gatekeeping function with reference to the motion record evidence. It would have had to come to the inexorable conclusion that the mold measurement and methodology employed by Dr. Crosby in coming to his opinions about medical care of cause of wounds to the right arm of the decedent was completely unsupported and thus not reliable. The Commonwealth has had 4 chances to tether the methodology proffered by Dr. Crosby to a study or other form of common acceptance or otherwise satisfy the apt Dalbert-Lanigan factors, yet has failed to do so each time. The failure is not an oversight or mere happenstance, whereas because the methodology of Dr. Crosby is not generally accepted in the relevant or medical or scientific community and thus cannot satisfy the factors. Very, very nicely written. Very nicely written. Good stuff, man. Very good stuff. Very good stuff. So I really like that motion. That was very well written by the defense. Okay, guys, I'm a little bit tired and I have to catch an early flight tomorrow. I'm going to see my parents. Yay, uncivil. And spend some time with them, and going to go visit the great state of South Carolina, so near Greenville. So I'm looking forward to that. It'll be nice to be in the upstate and hang with my dad and all that fun stuff. So I'm going on a plane tomorrow, and I'll be back in later. So yeah. So all that stuff. Okay, guys, I think I'm going to go ahead and sign off and try to get some sleep. It's only 8:30 at night, but I think I'm going to go to bed early. I have an early flight and I'm tired. All right. I've been on Civil Law. Until later, my friends, I hope all's well. Cheers, my friends, for now, and goodbye.